Hello and welcome to the intersection of money and politics. You're watching Political Capital with me, Karabo Letlatla. Politics and money met this week again at the State Capture Commission, where 3 of South Africa's 4 biggest banks lined up to tell the commission of their ordeal following their decision to terminate their Gupta accounts back in 2016. They were, of course, citing reputational damage to their brand. We'll show you more of that as we recapture State Capture for the week. Plus, there seems to be a short list of those willing to give testimony at the commission. And also, what can we make of the quality of evidence that is bare for us to see? I'll be speaking with Iraj Abedian later on in the show. But first up, let's recapture State Capture. It's slow going at the Zondo Commission of Inquiry. It's only day 13 of the hearings, and so far, we've heard allegations and applications to cross-examine those allegations, as well as a judgment. Deputy Chief Justice Raymond Zondo ruled last week that the Gupta brothers cannot cross-examine from a remote location, but they can still apply to cross-examine testimony, but only from South African shores. In the meantime, longtime Gupta associate and former President Jacob Zuma's son, Duduzane, has applied for and was granted leave to cross-examine the testimony of former Deputy Finance Minister Mcebisi Jonas. Duduzane is also expected to testify. But like son and unlike father, Justice Zondo had to urge former President Jacob Zuma to respond to some of the allegations leveled against him. Zuma is directly fingered in state capture by the testimony of former head of government communications, Themba Maseko, and also by former ANC backbencher, Fakey Mentor. But for now, Msholozi is pondering a response and or an affidavit to the commission. Day 9, 11, 12, and 13 were mostly about the numbers. On day 9, Treasury official Jan Gilliland told the commission of the escalating payments made by the government communication department since Themba Maseko's firing. All in all, 260 million of our rents made its way to Gupta media entities. But day 12 and 13 were all about the banks. The big 4 banks in South Africa closed Gupta accounts in 2015, a move which was not only challenged by the executive when Zuma formed an interministerial committee to look into it, but also saw Standard Bank CEO summoned to the ruling party's headquarters.
We banked a company by the name of Estina. Estina was a company which was awarded a contract in the Free State Province to develop a farm. And there was wide publicity around how the farm itself had not been developed, but substantial sums of money being paid to our client Estina. When we investigated, we found that large proportions of that money were in fact sent to Dubai rather than being spent in South Africa on the farm. That caused obviously was suspicious on our part. After a company by the name of Tegeta had concluded the agreement to acquire control of Optimum Coal Mine, we received an email from Oak-based laying claim to about 1.45 billion rands worth of funds that we held for a trust that had been established for the rehabilitation of the mine. We regarded that as suspicious. As a matter of law, these trusts, once set up for mine rehabilitation, are obliged to be ring-fenced in the process. The funds in the trust may be used for no purpose other than rehabilitation of the mine. Yet Oak Bay had asked us to transfer the funds to Bank of Baroda.
Yes. Who called that meeting?
My understanding, it was a request from the Secretary General of the ANC, Mr. Mantashe, made to Mr. Sim Chabalala, who is the Chief Executive of Standard Bank.
And then ANC was represented by who?
ANC was represented by Mr. Mantashe, Ms. Jessie Duarte, and Mr. Enoch Ngodongwana. The meeting then did go on to talk about the issue of the closed the Gupta accounts, we were asked to comment on the perception that we were part of white monopoly capital oppressing black business. We were asked to comment on the reports that we were taking instructions from people in Stellenbosch in closing these accounts. And we obviously rejected those out of hand. I must say it's the first time I've seen my boss, Sim Shabalala, get really angry. We were then also asked to comment about the concerns that these account closures might have for the employees, i.e. The inability of the Oak Bay entities to possibly pay their staff could affect the staff adversely, and we needed to comment on that. And I think our answer at the time was the fact that we were simply complying with the law and taking necessary steps to protect us. And the point that I think Sim made at the time was we employ 40,000 people. Our staff are equally important to us. And we can't do anything that is contrary to the law here and exposes us to international sanctions. Of relevance to this discussion is where it was said on behalf of the Department of Mineral Resources that on 13 April 2016, Cabinet established an interministerial committee to consider allegations that certain banks and other institutions acted unilaterally and in collusion when they closed bank accounts and or terminated contractual relationship with Oak Bay Investments. When we arrived at the meeting, there were 3 people attending the meeting on behalf of the IMC. There was Minister Zwane, Minister Olifant, and Mr. Jimmy Manye.
Was Mr. Jimmy Manye a minister at the time?
No, we asked on what basis he was attending, and he told us that he was an advisor to the minister.
There were similar stories from other 2 banks, namely FNB and ABSA, which were first to close Gupta accounts.
I requested that Mr. Kodongwani confirm that the meeting was still on. He came back to me and said the meeting was off. In my 32 years in banking, this is the first time ever I've received requests from a political party or an interministerial committee to want to discuss banker-client relationships. So I think that to me was the unexpected. I really didn't expect for any third party to want to question that relationship between bank and client. Secretary of the IMC, Ms. Kellerman, sent me the invite to attend a meeting. I got the request on the 22nd of April for a meeting to be held on the 25th of April. Again, I'm saying thanks for her email. We had anticipated that we would be given the requested information in order to allow us to meaningfully prepare for the meeting with the IMC. In light of the fact that we do not have the clarity and given current unavailability, we respectfully at this time declined the invitation for the meeting on the 25th of April 2016. An invitation is extended. It's holding further sessions, and I've been mandated to extend a further invitation to FNB to meet the IMC on Thursday, the 5th of May at 12:30. I am now mandated to further advise as follows. The IMC consists of the Minister of Labour, Communications, Mineral Resources and Finance. I responded back by saying, whilst we are prepared to engage with the IMC, we can only do so on the following basis. Firstly, whilst we can discuss the regulatory framework under which banks operate, we will not debate any client-specific matter with the IMC because that would actually be illegal. We can't discuss client-bank relationships with any third party. And the second thing we then added, secondly, we will only meet with the IMC if all the IMC members are present, in particular the Minister of Finance. Remember, they confirmed that the Minister of Finance was part of the IMC, as he is the responsible minister for the legislative framework under which banks operate. We'd like written confirmation of the Minister of Finance's attendance ahead of the meeting. We look forward to your response. There was at the time uncertainty regarding the powers of the IMC, and I believe that the declaratory order will avoid such situation in future and will encourage public officials to act in accordance with the Constitution and national legislation, particularly if one has regard to the fact that the acting secretary of the IMC extended a further invitation on 4th of May 2016 to an IMC meeting, which was after senior and junior counsel had already on the 25th of April 2016 provided an opinion that the IMC meeting was not authorized by legislation and would be unlawful.
For the record, the persons present at that meeting were members of the ANC NEC, being Mr. Gwede Mantashe, the Secretary General, Mr. Enoch Kondongwana, Ms. Jessie Duarte, and Mr. Krish Naidu, who I believe attended as a legal representative at that time.
And who invited you to this meeting?
The previous day, the 19th of April, I am informed that our CEO attended a meeting of BLSA, that's Business Leadership South Africa. At that meeting, she was approached by Mr. Gwede Mantashe to come to the meeting the next day. The meeting was opened by the Secretary General of the ANC, Mr. Mantashe, who indicated that the meeting was not to discuss client and customer information, predominantly because our CEO started the meeting by making it explicitly clear that should the meeting involve discussing client confidential information, we would not be able to partake in it. In fact, to use her words directly, she said it would be a very short meeting if we're discussing client confidential information. On that basis, Mr. Mantashe reiterated that the meeting was not to discuss client information. We referred Mr. Mantashe to regulators because it is a very serious allegation to make, and we have a very clear competition law process and competition law regulation in South Africa. So we referred Mr. Mantashe to regulators, in particular the Competition Commission on the SARB. We received an invitation on the 22nd of April 2016 from Ms. Advocate Zarina Kalaman, who from her signature in the email stated that she was the advisor to the Minister of Mineral Resources and acting secretary of the IMC, to attend a meeting on Monday, the 25th of April, at the offices of the Minister of Mineral Resources. And outlined in the request was the request to discuss or gain clarity on current media reports. ABSA respectfully declined the invitation to the meeting as we did not feel that we understood the nature of the meeting, and we did not feel that our questions were adequately responded to. On the 4th of May, we were invited to another meeting, which was to be held the following day, on the 5th of May. And again, the request was for ABSA or its representatives to appear in front of the IMC, and the scope of the discussion would be around public media statements that would have been made by ABSA around account closures.
Yes, and your response on page 201?
But we again declined to attend this meeting. We did not deem the committee to be an appropriate authority.
Thank you.
We did not understand the constitution of the committee, and we certainly did not understand why the committee would be interested in client bank accounts.
After the break, there's more questions than answers when it comes to the State Capture Commission. I discussed some of the questions with Iraja Bedian on the other side of this.